I will say it took a lot of energy, effort, and time to kind of put just the name together and working. We've all been working together really, really strongly, profusely, and just to try to come up with the name. Everyone was kind of involved in the emails and getting that together. So thank you all for all of your input and greatly appreciate it. But now I'd like to introduce Bill Bastuk. He'll be our first speaker. He was wrongfully convicted or wrongfully prosecuted in 2008. He's a former county legislator, town councilman, and former chair, founder and chair of ICAHQ.
Thank you, Heidi. Because I'm so short, I forgot. No, first of all, I just want to start off by thanking Heidi, Alexa, Marcy, and Linda, because we, on August 20th, the governor signed the bill establishing the Commission on Prosecution. This was a 5-year campaign, and I want to say, when you're doing a major piece of legislation like this is a landmark reform, okay? We're the first state in the country to have a Commission on Prosecutorial Conduct. And each year you pick up more and more steam, okay? You pick up more and more support. And this year, and we picked up more and more exonerees thanks to Jeff, because every year there's more and more wrongful convictions, there's more and more convictions being overturned. And this year, one of the key core groups that we picked up were really Heidi and Linda walking the halls, but not only walking the halls, but I can say for a fact that we moved 2 state senators, okay, Tony Avella and Hamlin.
Yes.
One was from Queens, one was from the Finger Lakes region. And the emotion and passion that Heidi and Linda showed in those meetings, I'll never forget you taking on Senator Avella and you breaking down when we were talking to the legislative assistant for the female state senator. And that moved them. That moved them a lot. And so you guys made a difference, okay? And Alexa, of course, you were the spirit.
Yeah, I
But no, making those trips and being emotional and shedding tears, that's what moves these guys, okay? And then especially when you've got some female breaks.
Gotta be female, men do it, doesn't it?
Well, Jeffrey and I have done it a couple times with a few tears. So, that being said, I just wanted to let you know that we hope to be doing a ceremonial bill signing with the governor shortly. As a matter of fact, Jeff ran into the governor at an event earlier on this week and asked that that take place, and something that Perry has been told too that they will take place. And everybody will be invited who can make it. We are requesting that it be done in the executive chambers and the governor's executive office in Albany, so that it can be as real as possible to the bill signing that took place on the 20th. The final bill, okay, if you've been following this in the newspaper, the Commission on Prosecutorial Conduct will be able to investigate complaints against prosecutors. There's a vetting process, okay? They're not going to review every letter from every inmate in New York State, okay? The Commission on Judicial Conduct got a process together 40 years ago to vet these things out, because there are people behind bars who should be behind bars, and there are people behind bars who should not be behind bars. But there are prosecutorial misconduct is an epidemic, not all prosecutors are bad prosecutors. There are some very good prosecutors, but the prosecutors who are bad tend to be serial violators. As in my case, when I was wrongfully prosecuted for raping a 16-year-old girl in 2007. There were diary entries that this girl had written, in which she predicted the date and time that I was going to rape her. There were diary entries in which she said, "I wish I could make this drama go away." There were also some psychiatric medical records, all of which the assistant prosecutor didn't believe was relevant. Because they go through and they're in charge and they're responsible for turning over what they deem to be relevant and what they deem to be consistent with what's known as Brady law or exculpatory material. So this is going to be a real deterrent to bad prosecutorial behavior and to those who try and cheat. And as Bennett Gershman says, get away with tricks in the courtroom. The other trick that they try and pull is in opening and closing statements, they step over lies. And they attempt to lie to the juries. In one case, in a double murder case in Queens, it was overturned in June of 1996, in June of 2016, which really helped our case, by the way. The judge who overturned this double murder, okay, was a pregnant woman, so the baby was due like within a week, okay. The judge reversed it due to pervasive prosecutorial misconduct. Bennett Gershman, who's an expert on prosecutorial misconduct, who we hope will be on the commission as one of the governor's appointments, said he had never seen a judge write up a prosecutor, take him to task the way he did. In 6 instances of these opening and closing statements, the prosecutor tried to get away with things. Unfortunately, there are objections, because if you have a good defense attorney, they're going to object. A lot of defense attorneys are not that well trained, or are anxious just to get the trial over with, and don't challenge in these opening and closing statements. But at one point, the prosecutor in this case lied about what the medical examiner said, reversed what the medical examiner determined. That's great length. Now, when the New York Law Journal called up this prosecutor and asked him what he thought of the judge's ruling, the only person that knows what that prosecutor said is Jeff. He said, "Well, I'm shocked. This was one of my cleaner closings."
No.
That's on record. That is on record, okay? That's the arrogance of the culture. That prosecutor, by the way, happened to be on charge of training younger prosecutors in the Queens DA's office. So we're going to have, the commission, by the way, can go out on its own, too. If they're hearing stuff about certain serial violators, as we call them, they can go out and conduct their own investigations. Now, the DAs have threatened to sue. They're claiming that this is not, that the commission is unconstitutional because of some constitutional language pertaining to the Court of Appeals making the final determination on discipline for the prosecutors. So what the governor's office did was they revised the process. And now the appellate courts are going to, the state appellate courts will be reviewing these cases. And what's happened is, this really should kind of,
Which cases?
charges of prosecutorial misconduct. What will happen will be the staff that will be hired by the commission, and there will be a $3.5 to $5 million budget for the commission. It's modeled after the Commission on Judicial Conduct. There'll probably be 3 offices across the state: New York City, Rochester, Buffalo, and Albany. They'll be well staffed with lawyers who understand the depth of prosecutorial misconduct, how to analyze it, how to look for it. There'll be private investigators that can go out and talk to people. those staff people will make a recommendation to the commission. The commission can actually subpoena prosecutors or assistant prosecutors. And then if they recommend a suspension, for example, it'll go to this joint body made up of the chief appellate judges in each of the circuits. This is brand new. It's something that the governor's legal beagles decided and came up with to avoid this constitutional challenge. Now, since the bill passed the assembly, the DA's Association has been saying, we're gonna be in court next week. Well, that was last June. There still has been nothing filed in court, okay? DAs also have threatened to boycott the commission. David Soares, the head of the DA's Association, sent out an email to all the prosecutors in the state telling them that if they got an appointment from one of the legislative leaders or the governors who are in charge of making these appointments, they should not take it. They should not accept it. That was so outrageous and infuriated Senator DeFrancisco and some of them here in the governor's office, as well as some other legislators, that they amended the bill. And they said they retired prosecutors can now serve. So they slapped them right back in the face, and that was one of the better amendments. They also have a rule that prosecutors cannot, that the 4 prosecutors who are appointed cannot not appear for more than 3 months at a vote, at a quorum, or they can be removed from the commission. And the reason that was put in is because, you know, there's a buddy-buddy system out there. And there was a fear that some prosecutors may be asked to rule on a case that, you know, the guys went to law school together, or whatever. So they decide that they can't make it that meeting, and then they can't make it again. They decide they can't make it again. Well, there's a limit now on how many times they can't make it. So they're being treated like children, because they have acted like children since the, so, that being said, our next goal, at least here in New York, is discovery reform. Okay, and we want the best discovery bill in the nation. Okay, it could happen to you. Drafted a discovery bill that was introduced by Assemblyman Lento in 2013, and that discovery bill we call the 3 A's for DAs. All the evidence automatically at arraignment. Okay, we don't believe there's. And if the prosecutors don't have all the police reports in hand, because that's what they're claiming, you know, in New York City, there's a backlog and stuff like that. There'll be language in the bill that will say that the prosecutors have a responsibility to turn over this material as it comes into them, not wait until trial, not wait until 2 or 3 weeks before trial, okay, as was the case in my case. My trial was postponed 4 times. I was supposed to go to trial in November, and then January, and then February. And my lawyer, who was a very aggressive lawyer, was not gonna go to court until he got what he knew, thought, or believed was out there, that the prosecutor kept denying existed. And she was lying. And he finally got it. Fortunately, we had a good judge who insisted that that happened. And, but that's what should happen, okay? It should happen. It should be the rule of the land. Some of the things that the prosecutors will be claiming, and we're gonna need you folks in the halls, okay? We're gonna need you folks walking through the halls, telling your story of what happened to Dylan. Because Dylan, there's a parallel between what happened to Dylan and discovery. And what prosecutors will often do too is lie. You guys know that, okay? They'll claim in a plea bargain that there's more out there. Okay? There's more, we can make it worse for he or she.
Well, that's what made Dylan not say that he was.
That's what happens a lot though. What happened to Dylan, we don't know how many people are behind bars right now that are villains, okay? And so, we want the best bill. They're gonna say that, well, they can't really turn over the addresses and the contact information for these witnesses, because if it leaks out, they'll get threats, in drug cases, get threats from gang members. Well, there's open file discovery in New Jersey, there's automatic discovery in Massachusetts, okay? There's gangs in Newark, there's gangs in Camden, God knows. There's gangs in Boston, and they're not bodies floating around in the river because these names are being turned over. There's what's known as can be issued as a protective order by the judge, so that the only person that gets this information is the defense lawyer. Okay. So that if in fact there is a gang member on trial, that gang member can't go and leak out the information to some other member of that gang. It's a realistic argument, but it has not been borne out in fact, and there are measures that can be taken to, in fact, protect that. I imagine that their new argument, either because they determine that they don't have a chance in court or they lose in court, will then be, well, there's a commission in place. So we're not gonna try and cheat anymore because we know we'll be punished by the commission. Well, that's bullshit too, okay? Because we know that judges try and get away with things even though there's a commission on judicial conduct in place. In closing, I just want to say this. This commission on prosecutorial conduct is going to change the culture of accountability for prosecutors. The part of it I love the most is that DAs cannot any longer just run on their batting average, on their conviction rate, and on these high-profile cases like mine. Mine was a high-profile case because I was a former elected official. Okay, and the prosecutor, she was very career-oriented. She wanted to be able to use my case to run TV ads on when she ran for DA, which she did try and do, by the way, last year, and she lost. Unfortunately, she just got elected judge. in Ontario County. Yeah, because that's what drives some of these young prosecutors. It's all a matter of batting average. But what's going to happen now is, if some prosecutor, if a DA, or if somebody underneath that, like the deputy DA, gets suspended, come that next DA campaign, whoever's running against that DA, it's going to be having a lot of fun. So the DAs are going to have to be much more careful. This changes the whole atmosphere of the DA's campaign. So, everybody in this room should be proud of themselves, and this is a great group, okay? We're going to be having a banquet. I know you guys are going to be putting together a table, and normally we have about 50 people at our banquet, and this year we're probably going to have about 150. Okay? And we're honoring Judge Frederick Block, who's an amazing individual. He calls me every Friday. He wants to know how things are going. He's bringing NBC News, Sharon Walters. He's bringing the National Review. He's trying to get somebody from CBS. He's going to get our Minister of Justice Award, our Ken Thompson Minister of Justice Award. Jeffrey Deskovic is getting our Private Sector Servant of Justice Award. And Steve Downs is getting a Private Sector Servant of Justice Award. And Tiffany Garriga is getting a Public Sector Servant of Justice Award for helping lead the drive to get City Council resolutions passed to support the commission. And we'll be honoring the other City Council members from Syracuse, Rochester, Albany, and Yonkers that also pushed through resolutions. So it's going to be a bit different. It's going to be a lot of fun. A lot of different types of people there. A lot of exonerees there. And, so, any questions?
What were the 3 A's for DAs?
All the evidence automatically and arraignment.
I mean, it's amazing what you've done. I just wanna start by saying that, but if I wanna be one of these people walking the halls, how do I get informed of all these things that you've learned and know for the length of the time that you've been making this happen?
Well, first of all, I worked for the state legislature in the 70s, and 80s and 90s, so I kinda had a little heads up on how things work and don't work. And, so it was, we will be communicating through your leadership, okay? We will be scheduling advocacy days well in advance. We're having a meeting on October 16th in Albany with the Innocence Project and some other key groups and some labor groups to begin to actually target our first January advocacy day. We want to get a bill introduced that all the groups can agree on, and I'm not going to get into all the politics of it, but there's been different groups that have different versions of what we should be pushing, okay? And we're going to try and build a consensus on that on October 16th and probably a meeting after that, so everybody gets behind one bill, all right? Because there are some pretty bad discovery bills out there. State Bar has a bill that's awful, okay? It's very complicated, it's got all these different provisions, different conditions under which discovery will be turned over, different timelines. Keep it simple. You don't have to, everything should be there. Don't make up a different rule for discovery for one type of a case and a different rule for another type of a case and all this other horseshit that's in the state bar bill. And that was basically the bill that the governor introduced, and we want the governor to introduce a good bill this year. And, the bill can be introduced, there's what's known as a pre-filing, that can be done in December. So that come January, the bill can start to be vetted, and it can be circulated to get sponsors and co-sponsors. That's where you guys will really be helpful. And getting sponsors and co-sponsors, we want to do the city council resolutions for discovery, just like we did for the commission. So there's a lot of different roles, and we equip you with talking points. What we generally do is meet in the cafeteria or Dunkin' Donuts, go over the day, okay, there's an agenda. We hand out sheets of talking points. People generally split up, okay, and that's the way it goes. And it's a lot of fun too, really. I mean, you're tired at the end of the day because you have, we'll probably have 8-10 meetings, 12 meetings, and so some of them are timed the same way. And we're going to do caps this year, or we're going to have hats. That was one of the things decided at the retreat. Tiffany's husband is an artist, as you know, Tim, and he's been ordered by Tiffany to come up with something. If you know Tiffany, like we all know Tiffany, she'll be all over Tim until he hits. So, yeah, that's it. I'm going to let John Ostwald from Soldier's Heart talk, and I'm going to be visiting Dylan next Sunday. I'm going to go there early Sunday morning, so I don't have to wait in line for too long on Sunday football.
All right.
I wish I could bring in a TV for dinner.
Oh, we have to make this day. Okay, thank you, Bill. Next we have John Ostwald. He is a professor of psychology, newspaper columnist for the Saratogan and the Troy Record, a Vietnam War veteran, inshore underseas warfare group 2, did I say that properly? And the author of War, Sacrifice, and Coming Home, whose work has been presented on TV, radio, and at national conferences. He is also on the board of directors of Soldier's Heart, which is a non-profit organization. Welcome, John.
Mind if I sit, is that okay? Fitz, is that okay if I sit?
Whatever you want.
It's my last time The last time I
My head's
spoke,
not in the way, is it?
I said I'm plagued with this same dilemma before every talk, wherever it is. The Buddhist monkey mind. Thoughts jumping around from vine to vine, my mind, thoughts. Not having any idea really what you would like to hear, but knowing that I'm giving you an hors d'oeuvre. I have so many psychological theories and all this stuff about healing and wounding and veteran stuff, but really not knowing what you would like. But hoping that I can present something in this very brief period that will stimulate thought for you. Really not inform you. You're not going to learn a lot by what I'm saying, but just to get you thinking more about some of the concepts. How many people here during the lifespan have suffered a wound, an emotional wound of sort, like the death of a loved one, terminal illness in the family, an unexpected tragedy? Can anybody volunteer an example? Go ahead. I know you found this.
No, I was just laughing, obviously everybody's had an experience. I don't think anything that's happened to me is unique, so I don't really wanna come forward with that.
Okay, no, certainly wasn't requesting the specifics of whatever it might be, but I think it sounds like you're correct. Most people have had some experience. Could you relate an experience?
Sure. Several years ago, when I was still with my ex-husband, his sister was tragically murdered by her husband, and then my husband committed suicide. Their children were left orphaned, so I then took those two children and my niece and my nephew at the age of 10 and 15. So I guess a point to that would be the trauma inflicted by the act of David killing Jill, then killing himself, but the domino and ripple effect that it had on everybody. And it's not only their children that were orphaned, and I took them in, my own children who were then displaced and I literally went from having 2 children to 4 children overnight, let alone teenagers, but it was very, very, very difficult.
That's a pretty profound tragedy.
Yes.
Unfortunately, all too common in our world. Some months ago, I went to Las Vegas to interview a trauma nurse, and I'm interested in the ripple effect. What is it like for first responders or military personnel or medical personnel after the aftermath of the shooting where 58 people were killed?
Right.
And I went to Parkland in Florida. I interviewed a teacher, an administrator, and a social worker where those 17 people were killed. And even though I didn't have any emotional connection to the school or the students, I remember walking around that monument, and I have pictures on it on a flash drive, and saying, my God, how horrific is this? How do you recover from this? I worked 17 years ago on a mental health team, 9/11, volunteer mental health team from this area. And one of our jobs was to escort family members to ground zero when it was still a crime scene. 16 acres of fires, electrical fires and all that. And we took family members there to the stage in the middle of ground zero that the city had erected. They wanted people to say goodbye to their loved ones. There was no loved ones. Most of those people were, incinerated. We also had to go into the cafeterias where the firefighters and nurses and other medical personnel were. And our supervisor said, just check in with them. And there they were weeping, just like little children. Virile men and women in uniform with weapons weeping. So there's some horrific tragedies in our world that are almost incomprehensible. On a personal level, I disappeared for like 2 years from the board of this organization, but Bill's organization. It could happen to you. I was in a gym in Florida when I got the call, came out to my car. It was a police officer from East Greenbush asking who I was and saying my son was in a car accident. And it was a long, nasty journey home. I wrote the eulogy on the plane, called the undertaker, and saw him in Albany Medical Center ICU, dried blood, all those tubes coming, and thinking to myself, I'm going to sleep in his room. This is probably going to be the last night we're alone together. Fortunately, excuse me, get a little choked up with the story. I haven't told it too much either. 2.5 years later, he's doing terrific. He's got a brain injury, traumatic brain injury, but he's doing really well, and he looks and acts like most obnoxious teenagers. He's 18 years old. But for me, for you, for all of us, and it's estimated, the research estimates 70% or more of us will experience, see, smell, hear some traumatic event in our lifetime. For all of us, there's wounding, whether we acknowledge it or not. For me, 2.5 years later, I'm doing really well with my mentor, Dr. Tick, who you have heard about, who I've been working with for 10 years. He told me 2 years ago, he says, you're in the acute stage of it. I'm having nightmares of my son in a cough and all that stuff. So that wounding is profound. For exonerees, the wounding is significant. I can read from this piece of paper on the flyer where it said, inside razor-barbed fences with no freedom to roam, a lot of precious years will be lost, taking everything day by day. I worked for corrections. I had a nice job in central office. I put on my suit, get my state car, go to the facilities. One day at a time here and there. It was a nice job. I never had to stay there. But I remember feeling profoundly that feeling of despair and anger in each facility. Can't imagine living in a place like that. 20 years ago, I picked up my cousin at a state facility. He got a sentence of 6 to life for drug sale, trafficking, all that stuff. He got in my car and he said, oh my God. And I said, what, you're free? He goes, no. This is the first time in 6 years I've sat on a chair with a cushion. So many things that you and I take for granted are obviously completely absent in the prison. And when you come out, just like you've seen in movies like Shawshank Redemption, the adjustment is often very difficult. Your decision making is impaired because everything is done for you. Some of my fellow veterans are here. They'll tell you about this. Every day they tell you where to eat, when to eat. Obviously the conditions are way better in the military than in the prison. But your decision making is like kind of like rested for a while. And now you're out and you can decide where to go, what to do. And even sometimes buying a newspaper or not seems like a big deal. Imagine if you were in prison for 5, 10, 15, 20 years. So what I'm attempting to illustrate is, for exonerees and people incarcerated, this journey is ever lengthy. It's lengthy for you and me and a lot of other people, but their journey is lengthy and some of the triggers are, again, significant. The good news is this, and maybe your grandmother said this to you. She said to you, you know what? That's just the way I am. I can't change. You ever heard somebody say that? I would always argue with that. And I would say, given the motivation for change, a desire for change, and the tools of change, people can change anything. I've worked with a lot of drug abusers in the New York metropolitan area. They used to run that on me, and I can't change, I'm a drug addict and all that. I said, you know what? I don't believe that. I don't care what kind of abuse you had as a child. You know, you can recover from that. It may take years, and it'll always be around. It'll always be sitting there, but you can make it have less, weight on your shoulder over the years. So for those of you who are gathered here, you are some of the tools of that resilience, of that recovery. So for you and I, we are sometimes wounded, but we also are the tools of recovery. That's it.
sure of the order. Jeffrey will speak next, and then I'll speak last. Jeffrey, you'll be speaking next, and then I will speak after you.
However you wish.
Is that all right?
That's fine.
It's my honor and pleasure to introduce Jeffrey Deskovic. A little bit about Jeffrey and where he's been and what he has accomplished. Jeffrey Deskovic, M.A., is an internationally recognized wrongful conviction expert and founder of the Jeffrey Deskovic Foundation for Justice. The foundation to date has freed 7 wrongfully convicted people and helped pass legislation pertaining to videotaping of interrogations and improved identification procedures. Jeff's body of work includes delivering 200 presentations, authoring more than 200 articles in 9 different publications, meeting with elected officials and testifying at legislative hearings, and participating in uncountable television, radio, and print media interviews. In effect, trading privacy in exchange for awareness. Jeff is also an advisory board member of the It Can Happen to You Coalition, which spearheaded the efforts at passing legislation in New York to create the country's first Commission on Prosecutorial Misconduct, which was recently signed into law. Jeff has a BA in Behavioral Science from Mercy College and an MA from the John Jay College of Criminal Justice, which includes a thesis on wrongful conviction causes and reforms needed to shore up those cracks in the system that lead to wrongful convictions. Certified as an instructor in New Jersey police academies, Jeff has instructed 7 soon-to-be graduating classes of police officers in ethics and best practices, and has twice co-taught a wrongful conviction course as an adjunct professor at Rockland Community College. Jeff was an executive producer of the Survivor's Guide to Prison and is a consultant to the show Psycholytics, which is a long-term discussion show both helping to line up guests as well as appearing on screen. Working with New Yorkers against the death penalty, Jeff helped ward off capital punishment, reinstatement efforts in 2007, and then participated in 2009 campaign with the Connecticut Network Against the Death Penalty, repealing capital punishment here in Connecticut. Parachuting into battleground districts, doing media interviews, testifying at legislative hearings, and meeting with elected officials. Jeff has previously won the New Yorker of the Week in 2015 Humanitarian of the Year and 2018 Distinguished Alumni Award for the John Jay College of Criminal Justice. He is enlisted in the John Jay Criminal College book 50 at 50, which features 50 alumni who embody the John Jay mission of compassion and commitment to service as a fierce advocate for justice. Jeff is currently in the 3rd year of law school at the Elizabeth Hubb School of Law at Pace University in pursuit of his dream of exonerating others as an attorney. Jeff dedicates his life to fighting wrongful convictions because he spent 16 years in prison from age 17 to 32 for a murder and rape that he did not commit prior to being exonerated by DNA testing. Prosecutorial misconduct was one of the major causes of his wrongful conviction.
Thank you. Doing my best to try to finesse the hand that I was given in life the best way that I can. And I consider that I went through what I experienced, that I'm doing what I'm meant to do, and that's how I make sense of what happened to me. I was wrongfully convicted of murder and rape. The year was 1990. Peekskill was a small city with a population of approximately 25,000 people. Murders were very rare. So when this murder happened, it created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to the kids in the school. In the course of the police investigation, the police spoke with many students from the high school, and some of them told the police they might want to talk to me. I guess the theory is that people who are quiet into themselves commit heinous crimes. So that's what the police said attracted them to me. The other factor which they said attracted them to me is that they said that I was overly upset at the victim having been murdered. In other words, that my emotional reaction was disproportionate to what my actual relationship to her was, which was to say really no relationship at all. She was in a pair of my classes, two of them as a freshman, one as a sophomore. I knew her name, she knew mine. That was the extent of it. We really weren't even really on a high-by basis. So the emotional reaction, the police articulated that was interpreted as like a remorse for having committed the crime. The police sought a psychological profile from the NYPD of what the psychological characteristics might be of the person who committed the crime, and I had the misfortune of matching that psychological profile. I was known to the victim, I was in high school, I was quiet, I was to myself, so I guess that reinforced the police focus in on me. So for about 6 weeks, the police played this cat and mouse game with me, in which half the time they would speak to me as if they needed my help to solve the crime, and the other half the time they would talk to me as if I was a suspect. So they would say things like, well, kids won't talk freely around us, but they will around you. Let us know if you hear anything. They made me the center of attention. They made me feel important. They used to ask me my opinion and then congratulate me on my opinion being correct. They used a game known as good cop, bad cop, in which one officer takes on a more aggressive role, whereas his partner pretends to be opposed to what's going on, yet somehow powerless to intervene. And of course, the purpose of this tactic is that when a person is being questioned becomes frightened, it's only natural that you would look to a friendly face for assistance. That intersected with my growing up, because my father was never involved in my life in any capacity, and so I began to look up to this cop who was pretending to be my friend as a positive adult male role model. My fantasy childhood career, what I wanted to be when I grew up, prior to my ideas evolving when I had my teenage years, is I wanted to be a cop. So this unexpected early opportunity to do this quasi-police work is what, along with my age, is what allowed the police to pull the wool over my eyes, that, a 16-year-old could really and truly help the police solve a homicide. Yeah, sure. So eventually they got me to agree to take a lie detector test. They told me that something new would come, some new information had come into the police file, and they wanted to share that with me, and that would allow me to be even more helpful to them. Of course, before they could release that, I would have to take and pass a polygraph. I guess, kind of not dissimilar to how somebody working for an intelligence service or maybe military intelligence would have to pass a polygraph and weren't some secret agent. So I agreed to take the test, and so the next day, rather than go to school, I went to the police station where I had heard through the rumor mill that other people had been polygraphed there. So I was fully expecting it to happen there. But instead, they drove me 40 minutes away across county lines from Westchester County to Putnam County to the town of Brewster. Because it was a school day, my mother and grandmother with whom I lived thought that I was in school, and therefore they did not call around looking for me. They thought that everything was fine. I wasn't given anything to eat the entire time that I was there. I didn't have an attorney present. There were 3 cops who came there from Peekskill. The lead officer had read me my Miranda warnings in the car before we set out on the trip, but I didn't understand what Miranda warnings were, and I didn't really even understand why I was being given them in the first place. I mean, after all, I was there to help them at their request. So there were the 3 cops there, but then there was the polygraphist, who was a Putnam County Sheriff's investigator, who was dressed as a civilian, and he never identified himself as a cop, so I never knew he was a police officer, and he never read me my Miranda warnings. He gave me a 4-page brochure on how the polygraph worked, and it contained a lot of big words. Again, let's keep in mind I'm 16 years old at that point. I'm a sophomore in high school. I didn't understand the big words in the brochure, but I dismissed my own concern rather rapidly. Well, who cares? I'm here to help the police. Let's just get on with it. We can finally stop this silliness when they occasionally start talking to me like a suspect, and like we can just focus in on task here. So I was put into the small room, and the polygrapher gave me many cups of coffee, and it seems pretty clear in hindsight that the purpose of that was to get me wired up in preparation for the polygraph. So from there, he attached the polygraph machine to me, so I was kind of immobilized at that point. He took about 10 minutes playing around with the knobs and pretending to tune the machine into my body's biofeedback, and then he launched into his interrogation. So he invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. The way he was conducting himself, and given the fact that I really wasn't used to talking to grown men, made it a really frightening experience. So he kept that up for 6.5 to 7 hours. Per the polygraph literature, I would later learn in discovery through the lawsuit process that the longest anybody should be polygraphed would be 3 hours, and even that would be the uppermost limit. And here he more than doubled that up. He was supposed to audio or videotape the polygraph because the particular method that he used, the Arthur method, was known for producing false confessions. But even though polygraphers claimed to never miss a day during his training on it, and it was in all the literature of the founder of that method, he claimed not to get the memo that you're supposed to audio and videotape. And I'll share another thing with the polygraph is that later on his charts came up missing. So there was no way to have them independently assessed. So towards the end of the interrogation, he said to me, "What do you mean test results that you did? We just want you to verbally confirm it." So that really shot my fear through the roof, beyond what it already was. And at that point, the officer who had been pretending to be my friend, he came in the room and he told me that the other officers were going to harm me. He'd been holding them off but couldn't do so indefinitely, that I would have to help myself. But he added that if I did as they wanted, that they would stop what they were doing, that I could go home afterwards, I was not going to be arrested. Being young, naive, frightened, 16, really in fear of my life. The fact that I didn't know where I was and that nobody else knew where I was either loomed quite large. I was overwhelmed emotionally, and there was the push-pull dynamic in play. On one hand, he introduced the possibility of harm, but then on the other, he threw me this false life preserver, and I just wanted to get out of there. So I grabbed hold of that item, that metaphorical item, and I put all my belief in it, and I made up a story based upon the information they had given me that day and in the 6 weeks run up to that, as well as some items in the newspaper. But I spoke faster than where I could make stuff up, and so that added to my being overwhelmed, and by the end of it all, I collapsed onto the floor, crawled into a fetal position, and I was crying uncontrollably. I remember at that point, the lieutenant then burst through the room, and he was yelling and screaming, insisting that I repeat everything, that he had to hear it for himself, and that we could be there all night if I wanted to be. So I repeated everything. Needless to say, I was arrested. I was charged with murder and rape. So before I went to trial, the results of a DNA test came in from the FBI lab, which showed that the seminal fluid didn't match, that was found in the victim didn't match me. That's where that prosecutorial misconduct came into play, because really that should have been the end of the case right then and there. So when there's an autopsy done, there's medical, there's written and audio notes which are taken contemporaneously as findings are made as a way of ensuring authenticity. So it was only once the DNA results came in from the lab, those came in about 6 months after I had been arrested. So 6 months after doing the autopsy, the medical examiner, wanting to help the prosecutor combat the DNA test results, he suddenly remembered that he had found medical evidence which he had failed to document before. There's hundreds of autopsies later, he remembers this. That he said he found medical evidence showing that the victim had been sexually active, which is basically in a flowery way, he was really trying to say, look, the victim was sleeping around, so it doesn't matter that the seminal fluid didn't come from me, that doesn't mean you're innocent. It just means you slept with someone else before you raped or murdered her. Which really, it's not even really that good of a theory, because that means there would have been at least 2 DNA profiles if that would have been the case. And that never appeared in any of his early reports. So he doctored that to help the prosecutor. Taking his lie a step further, the prosecutor named another youth by name that he claimed had sex with the victim, but he didn't set the proper evidentiary foundation. He didn't have a DNA test result performed. He didn't even call this other youth as a witness. He just made the unsupported argument to the jury. The police tried to help the prosecutor also. They falsely attributed a statement to me. It wasn't enough that they coerced a false confession. They had to add to it. They claimed that I said to them that I didn't know if the perpetrator ejaculated or not, which that word was not in my vocabulary as a 16-year-old. And much like the medical examiner's fraud, that never appeared in any of the police reports until after the DNA test result appeared, so that wasn't in the early reports. The public defender was terrible. Well, firstly, let me say in fairness that another aspect of the prosecutorial misconduct was that the prosecutor never turned over reports to my attorney that the medical examiner, who was moonlighting as a defense expert in neighboring counties, that prosecutors and judges were complaining about him because, he was helping people get away with crimes. Somebody died in police custody, and he claimed it was a drug overdose, but there were bruises on the victim's head, and there was no indications that there was any drugs in the system. There was times where he was caught lying, basically. So whichever way the money flowed is the way he testified, and it got to the point even where I can't remember if it was the prosecutor or the district attorney himself that said, look, we can't use him anymore. If you try to use him, then we need a second backup opinion because he's just not reliable. So the Westchester District Attorney's Office knew that, but they never told my attorney that, so we didn't know that was a line of impeachment that could have been pursued. Lastly, one day before officially getting the test results back from the FBI lab, he ran to the grand jury to indict me. So he asked to be able to not present the DNA findings to the grand jury. So my lawyer, he never interviewed or called as a witness my alibi. I was actually playing wiffle ball when the crime happened. He very rarely met with me. When he did meet with me, and I tried to explain to him I was innocent and what happened in the interrogation room, he was always shutting me up. One time he told me he didn't care if I was guilty or innocent. He should have never represented me because of a conflict of interest. This other youth that the prosecution was making the story up about was represented by another member of legal aid, and specifically by the lawyer who was supposed to be supervising him on my case. And so that prevented the defense from calling him as a witness, from the defense from asking for a DNA test result. My lawyer never explained to the jury what the significance of the DNA was. He didn't use that to argue that this so-called confession was coerced and false, and that the DNA proved that. I wanted to testify at the pre-trial hearing. When there's a confession that's introduced as evidence, they have what's called a Huntley hearing, where the judge has to determine whether or not somebody was given their rights, and if they knowingly waived them, and whether or not any of the statements were voluntary. That's the procedure before the evidence could be used at trial. My interrogation was not videotaped or audio taped. It was no signed confession. It was just the cop's word. And so they were able to leave the threat and the false promise out of the story. So I wanted to testify and add those facts, but my lawyer wouldn't allow me to. He told me that he hadn't decided if I was going to testify at the trial or not, and therefore he didn't want to have me give testimony before that, saying that the prosecutor could use that testimony to cross-examine me with at the trial if I testified and make it appear as if I was lying, even though I wasn't. So he didn't let me testify there, but really that tactic really didn't make much sense, because first of all, if I had been believed, then the statements would have been ruled involuntary and lacking any other evidence, there wouldn't have been a trial. And secondly, if it really went badly, I didn't have to take the stand, and if I didn't, there would be no way that the testimony could be used. But then when I got to trial, he wouldn't allow me to testify there either. He told me that it wasn't his job to prove that I was innocent, it was up to the prosecutor to prove that I was guilty, and he didn't think that it happened. Yes, it's a legal principle, but it's a rather naive way to practice law. That's not the truth in reality. In reality, if a person is falsely charged, you have to do everything you can to prove that you're innocent, or you run a risk of being wrongfully convicted. Add it all up, I guess it wasn't too surprising that the jury found me guilty. I'll never forget the day I was found guilty. It felt like I was in some sort of nightmarish alternative reality, because to my way of thinking, at least up until that point in time, only the guilty were convicted. But they said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent. I referenced the DNA to support my contention. He actually told me on the record, maybe you are innocent, conceding that there was a doubt. I mean, I guess how could there not have been a doubt since the DNA didn't match me? But that didn't lead him to step up for justice and exercise his discretion by overturning the conviction, which he could have done by reversing any number of inaccurate rulings that he made against me in the course of the trial. Instead, he took the easy, politically expedient way out, which was to sentence me to a term of imprisonment of 15 to life. So I rather naively thought that the court system got better the higher up you went. I went to the appellate division where my arguments were that my Fifth Amendment rights had been violated, and that and my innocence, wrapped around different legal theories, that there was legally insufficient evidence, that the prosecution hadn't proven guilt beyond a reasonable doubt, and that the verdict was against the weight of the evidence. I had 6 issues of law besides that. So the appellate division ruled that I was not in police custody at all, that I was in fact free to come and go as I wanted, and not being in custody, that meant a different set of rules and law applied. And they ruled that interrogation was voluntary. They wrote that there was overwhelming evidence of guilt, which is still kind of a head scratcher, considering that the DNA didn't match me. They found overwhelming evidence of guilt in a case where someone was factually innocent, and go figure that one. And then they took care of all of my other claims in one sentence. They wrote that we looked at the defendant's remaining contentions and find them to either be without merit or not preserved for review. And as bad as that decision was, all of that was the most that any court ever wrote. My re-argument motion was denied in front of the appellate division when my lawyer pointed out that their decision was running contrary to the facts and the law and giving illustrations of that. But that was taken care of in one word, denied. The procedure for going to the New York Court of Appeals is you have to get permission to appeal to the court. And if you get permission, then you're allowed to fully brief and argue the issues. The Court of Appeals ruled that there was not any merit in law to justify reviewing my case, so they were declining to review it. I lost in federal court because the court clerk gave my lawyer the wrong information pertaining to the filing procedure. So my petition arrived 4 days too late, which the District Attorney of Westchester at that time, Janine Pirro, her office took the position that those 4 days were prejudicial to the people and that therefore the court should simply rule that I was late and never bother to reach the merits of my arguments, which again included my innocence argument and included my Fifth Amendment claim. The court sided with the district attorney, and so that meant I was not able to argue my issues anymore. I was relegated to arguing that that procedural ruling against me was inaccurate. So my lawyer appealed and got permission from the Federal Court of Appeals to appeal to them, where the judges hearing the arguments were Judge Rosemary Pooler and future U.S. Supreme Court Justice Sonia Sotomayor. My lawyer argued that this was not a delay caused by me and my attorney, but instead by the court clerk. I don't think we need much education in the law to know that that's a valid argument. My lawyer argued that upholding a ruling like that would cause a miscarriage of justice to continue, which kind of backdoors my innocence argument in the DNA. This is a contextual issue, and that overturning the procedural ruling would cause, would open the door rather, for me to get further DNA testing. But once again, the district attorney opposed, and the court upheld the lower court decision. My lawyer moved to re-argue the case in front of them, requesting that all the judges on the circuit hear it and make a ruling. But that was denied, and the U.S. Supreme Court declined to give me permission to appeal to them. So at that point, I had 11 years in prison, and my appeals were exhausted, and since I wasn't litigating anymore, why would I need a lawyer? So the state didn't furnish me with one anymore. I was permanently locked out of the courthouse, with the only way back in being if I could find some previously unknown evidence of innocence or of some retroactive change in the law happened. So for 4 years I wrote letters looking for a lawyer and an investigator who would take my case for free because I didn't have any money to hire anybody. I had to hope that they could somehow find some new evidence. I wrote large law firms, I wrote nonprofit organizations, I wrote media members, I wrote churches and faith-based organizations. If I could come up with a theory, an indirect route, what somebody could do to set in motion a chain of events ultimately culminating into the impact of my having a lawyer. If I could come up with a theory, I wrote the letter and I took the chance and I waited. And I never took for granted that they would understand how they could possibly help me. I was very clear about that. I wrote hundreds of letters, but I rarely got any responses. I went to the parole board, but generally speaking, they want to hear the applicant to express remorse and take responsibility. The last thing they want to hear is assertions of innocence, but I did it anyway. I sent them my legal paperwork for the sections dealing with the negative DNA test result, but they didn't want to hear that. They asked me a question about an aggression replacement training program. I gave them the answer. They commented, one of the commissioners commented, they said, well, that's good, Mr. Deskovic, because you're going to need those skills to return back to society. Good luck. Well, the procedure is that you get a decision in the mail 3 days later, and considering how that interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and would be going home. When I got the letter in the mail, it noted my excellent educational record, that I had a good disciplinary record, that I had some letters of support, including that from a prison employee. But nonetheless, I had been convicted of a brutal and senseless crime, and as they saw it, to parole me would be to lessen its seriousness. and so they ordered me to appear in front of them 2 years later. I knew a lot of people who were working on years 25 and 30 off of a 15 to life sentence, where they would go to the parole board and be turned down, and go back in 2 years and be turned down again, and have that cycle continue in a seemingly never-ending spiral. So when I got denied parole, I felt fairly confident that I was going to die in prison for a crime I didn't commit. I eventually wound up in touch with an investigator. I wrote a book authoring care of the publishing company, and she said that she couldn't work on my case because she was too far away, but that she would network for me, and she suggested I write the Innocence Project again. She lobbied them from outside the organization. She got other respected legal entities to write letters to them, and I got lucky that one of the intake workers there was very persistent. My lawyers turned down my case a couple of times. She kept representing it using different theories as to how the DNA could be used in order to constitute something new. One of her ideas was the winning one, which I had suggested in one of my letters, which was the DNA data bank. So getting that representation was the first of 3 major occurrences. The second thing was that Pirro left office, so our successor was not as dug in.
To go on TV.
The third thing was we got lucky. We were playing a long shot. We were hoping that the actual perpetrator committed another crime and got caught for it, which would have resulted in his DNA being put into the data bank. And we did in fact get lucky. He had killed a second victim 3.5 years later after committing the crime in my case. And so it matched him, and confronted with the evidence, he admitted he was the person who committed the crime. He admitted it to a reporter on video camera as well. So on September 20th, 2006, my conviction was overturned after 16 years. I reported back to court November 2nd, 2006, at which point all the charges against me were dismissed on actual innocence grounds. I never got an apology from anybody that was involved in my case. I got a symbolic apology from the prosecutor in the courtroom and the DA, but they weren't their counterparts that were involved in my case, and neither was the judge. So, changing gears, I just share a little bit. I've never really spoken about the 5-6 year campaign that I undertook, if it can happen to you, culminating in the passage of the bill. So I wanted to do something new for a change, and the event organizers cleared the way for me to share some stories of what it took to get the bill. I mean, this was a really long and hard road. Albany is 2.5 hours away from where I live, so there was a lot of getting up early in the morning, around 5 o'clock in the morning, and these really long trips. I served as the liaison of the coalition group to the exonerated community. I have more of a rapport with them. They see me as one of them, and I am one of them. So, from selling them on the coalition, explaining that what we're doing is worthwhile, that there's nothing funny going on here, that I'm really involved, to sharing with them about the commission and calling them up and basically asking them to, sometimes it was like getting personal favors. I need you to come with me on this trip up to Albany, or I know you don't like doing media interviews, but I need you to come to the media interview, and I need you to come to the press conference, and come with me to meet the elected officials. So from doing the outreaches and then having to confirm, imagine 5 and 6 people, you set it up, and then you have to remind them 3 days out and the night before, and a lot of the guys were not compensated. So I had to get involved into the less glorious side, the hidden side of advocacy, the logistics. So how are you actually going to get to my house, and then ferrying people up and going back down and going out of my way to drop them off, and sharing with them, these are the points we need you to make. We choose the language. This is the general point, to meet with an elected official, that's not a regular conversation. That's really kind of a skill set. You gotta introduce yourself super quick, you got like 1 minute to tell your story. You have to then mention the policy issue, maybe not the nuances of it, but just how the commission would have made a difference. And you get out, and you're done. That's, so from working with them that way and getting, requesting that they make the personal statements, one of the tactics we did is we got written statements from the examinees, and we had them sign on the sign-on letter at the end. When we passed the bill, we were trying to get the governor to sign it. Bill had the idea of getting a sign-on letter, and so we needed to get the examinees to sign on, and so I had to encourage them to do that, and we had statements and stuff besides that, and then coordinating too. I learned a lot in this campaign from dividing up the political board. These are the people that are with you. Don't waste much time. You're never going to move these people. The fight is in the middle. But then dividing up, and well, you're from his district, and so you're going to pair you with this set of people. So there's that tactic. There's speaking at the press conferences, and I can tell you it's not pleasant for me or for anybody else. Imagine getting up at 5 in the morning, you go on a long trip, and you got 5 minutes to speak at the press conference. It's really not worth it, except for the fact that you're making an impact. So that's not an easy thing. Sometimes I did that just to meet with 2 people or with 1 person. A lot of the spade work I did before It Can Happen to You came into play. I knew different people in certain groups that I was able to help connect to Bill, and he masterfully took it from there. Just the skill building of building a coalition from the summit, and collecting ideas and organizing them and winnowing them down, but you have to do it in an inclusive way so that it's not a dictatorship, because everyone will walk away from you if that's the case. From that to the monthly phone calls, to meeting every 2.5, 3 months in Albany again, to the gala dinner. I believe the true test of how committed somebody is whether or not you're willing to plunk down your money, whether that's the cost of traveling to places or buying tickets to something. Whatever's within your means. So I have a little bit because of my compensation, and so at times I bought tables, and I needed the exonerees there, but we're trying to raise money for the work that we do, because it's not free to do advocacy. So buying tickets for people that couldn't otherwise make it. So that was sometimes from doing, because I live on a budget, I know what it is to make $250 a week. I lived like that for 5 years, so I don't spend the compensation that I get. I have it invested into some conservative things, and I make a certain amount of money that you can safely make, and I pretend I don't have nothing, and that's my salary for the month, and I don't spend anything past that. So sometimes, with maybe like 10 days left in the month, I'm looking for the time of getting paid. Maybe like $300 or $400 of disposable income left, but that's the sacrifice that you do. I remember marching. We got the banner. Bill, I usually do a special project each year. Bill has one idea or another that he pitches to me, but he tells me that it's worth it and it's right. And so we do one thing or another. I remember we got the really big banner, and I marched, and that was a really long, hard task. In the heat, there is no speaking portion. You just walk and you hold the banner, and it's long, and you hope to get the advertisement that you can. A lot of, scheduling of events, you know, it's a lot. Just to do this event is a lot. There's a lot of hidden time costs, from lining up speakers to bios to is the flyer exactly correct to, you know, thinking through the logistics and the order of things, and, you know, it all counts. At one time, and so kind of doing this work, you know, the idea is it's all hands on deck, you know, you do everything. You do everything that's needed. At one time, I edited the Wednesday Watch for a while, and I wrote some of the articles, and then I was able to pass that off, and I shared a couple of times, and then other, you know, and then it was great, you know, but it's an example of, you know, trying to do some of the small things. Building the coalition, I mean, Bill was always bringing people in, newer people. You have to keep going forward, but you have to bring new people in to be effective. You can't forget the people that have been there, but you also have to make the new people feel very much a part of everything and very much, you know, invested, like they have a say in things. So that's always a tightrope. That's always a tightrope walk. Getting memos of support. We got memos of support for the commission, and Bill mentioned the resolutions. Those things were big, you know. And then there were times, you know, we were disappointed. You know, a lot of times we got disappointed. We made the long trip, and we actually wound up only being able to speak to staff people, not the elected officials. Now, sometimes that'll happen as part of the course, but other times we were promised that it would be the elected, and it actually wasn't. But more than that, I remember a couple of years ago, you know, we were kind of bridesmaids there. We came up to Albany, you know, and we were told the bill was going to pass, and the bill didn't pass. But we went to eat and have dinner because you have camaraderie, and in a way, that's kind of advocacy too, because you advocate with the advocates, but you also want to keep that camaraderie going, because that's part of that cohesion. I'm a chemistry person. I have to like the people that I'm with, so I like to develop personal relationships of one kind or another with the people. So we, you know, that's another thing I learned from Bill. You know, we will always have dinner, or we would do something together. So we went to dinner that night. And by the way, you know, come on, they're not going to pass it, and yes, they are, and trying to keep people in that want to just be done. And we were at dinner. We went to dinner, and we were getting ready to go home. We got the call. We got the call from the legislature. Don't go home. We're going to pass the bill tomorrow. You know, Albany's quite a ways, and this is like around 8 or 9 o'clock. And no one's going home to come back. So it's either, you know, but it becomes a trap, because if you come this far, at what point do you walk away? The more you put in, the harder it is to walk away. So we stayed over, with no shower gear, no change of clothes, nothing. And went back over to the legislature, and we sat there in the gallery, and we waited and waited, and we waited some more. And eventually it was 8 or 9 o'clock, and we were told that, you know, we was not going to happen. So we went out to eat. And then we get ready to go home, and we were told again, don't go home. We're going to do this tomorrow. So we stayed a third time. And, so we went back over there the next day, and maybe around 2 o'clock or 4 o'clock, suddenly everybody had bailed on Senator DeFrancisco, all the commitments he had. Suddenly, you know, nobody wanted to back it, and I was at the same point where all the counter lobbying that the district attorney's office was doing, and as Bill put, everybody got DA-itis. People were going home to not be caught in the middle between DAs and us. You know, but the DAs were stronger than us. You know, so they didn't vote for the bill. So that was a really big heartbreak. You know, there's always ups and downs of every campaign. You know, at one point I thought when the Senate passed it, I mean, I felt like, you know, when the argument started, the DA started coming with a constitutional argument, and the Attorney General's office leaked the memo, it's to the governor, well, it's certain parts are unconstitutional, and it appeared as though we were dead in the water, and we were getting op-eds that were coming out. Finally, I helped orchestrate some of them and using media connections, and then that happened, it looked like we were dead in the water. But we kept at it. There were new partners that came into play. Cattell came into play, and the Innocence Project came in, and we had this rush of organizations that suddenly wanted in. Now, we had been going it with just our core group and partners we added along the way, but suddenly everybody and their mother wanted in when the Senate passed it. But you accept the help, and you gotta be gracious, and you need the extra memos of support, and that manpower and expertise was really important. So people were working around the clock. Rebecca Brown was working around the clock, Bill was, Marvin Schechter, Steve Downs, so the negotiations going back and forth, but it didn't look like we were gonna pass it. And it came, then we were doing things like, from using on social media, we used to always take pictures and have pictures taken and recording things and trying to paint the captions exactly right to not be too long, but to get to the point and make use of the drama, and having people make phone calls, and a lot of times those campaigns, we were in a losing effort. So to then go back to use them some more, and it was the tactics are what they are. And suddenly it came down to the last day. I remember around 5 or 6 o'clock, we had a Google alert set up on the commission, and I remember I saw the article, the governor passed it. I remember jumping up and down and screaming. There were a couple of people that were there with me, and then making phone calls to everybody, posting on social media. We won. So those were some really those were some good moments. As an advocate, there's always a tension. I find a tension always, between personal life and advocacy life. Many times I had plans with people, social plans, and then one opportunity or another to do this speaking engagement or go to this meeting or do this media interview. So I always put my personal stuff behind, but there is always that tension at times. I wanted to take a vacation, but Bill needed me in Albany, so it's, but then to hear also, well, why are you wasting your time with that, and you're never gonna put this behind you, you're never gonna get better, you're always talking about it, you're always involved in it. Look, that's stupid. What are you getting out of that? Why don't you just do something to make some money? Why are you bothering with all this? Look, man, they're never gonna do this, okay? They're never passing this bill. Just stop already. Enough. Enough. So you wrestle with those external thoughts from other people, and but you overcome. I overcame, and I kept going. I feel pretty comfortable in my skin now. I feel like I've grown as Itchy has grown, but there were plenty of times that I felt like myself, I feel like I would have been better off, if I had been convicted based on a lying informant, for example, where somebody misidentified me. Well, at least it's not me, right? It's not me making a false confession. So at times I've struggled with that in the past, and I felt, I should probably, I felt like this moron, I should probably just crawl under a rock someplace and like never be heard from again. I mean, you idiot, why would you run around telling people that you falsely confessed to something and, wound up costing you 16 years. So, and is this stuff really all making a difference? So those things, are times that I've wrestled with that. I think that anyone that's really involved in this really would have to wrestle with that at some point until you eventually, get past that and you get comfortable in your skin. So I'm past that, but those things have been difficult. I think that the era of going it alone is over for different nonprofits. I think that the coalition model is the best model. I do believe the strength in numbers, and I'm glad that Bill Bastuk came along when he did. I've been doing advocacy work for a really good 6 years, prior to him entering the picture. legislature. I used to be speaking and meeting with elected officials and, do the press conference, do the whole bit, which is how I have my own body of knowledge. But, they would welcome me in the office and they would skin and grin and pat me on the back on the way out, and they would do nothing in the end. But, it's, I'm really happy that we finally got something done. I can feel like we did get something done in the legislative arena. The videotaping and ID reform that was referenced in the introduction were only partially satisfying. The legislature really watered down what was pushed for. It was supposed to be videotaping everything. And instead they changed, well, we're not gonna videotape second-degree murder. We're not gonna videotape certain sex offenses and certain drug offenses. And, that wasn't what we wanted. That wasn't what I fought for. The remedy was supposed to be, they can't use the interrogation if they don't interrogate, but now they can use it, and the worst case scenario for the prosecutors, if they, in terms of their evidence, if the cops don't videotape, well, you get a jury instruction. But that's not, I don't see that as very much of a deterrent. I won't say it has no impact, but it's only partial. The ID reform was watered down, but this bill was not. In many ways, I feel a level of satisfaction with this bill that I didn't with respect to the other things. And thank you.
I'd just like to say one thing too, about Jeff, and this also applies to Steve Downs. Itchy was operating on crumbs, okay, and Terry and I were taking money out of our pockets to spend for basically our hotel expenses. And I was spending time at hotels in New York City. And because of Jeff's accommodating me in his palace in the Bronx, and Steve accommodating me at Camp Downs, we saved thousands and thousands of dollars. And there's no way, financially, we could have made this through that with not only Jeff's donations, but the expenses of having free lodging. And one of the things I learned many, many years ago, when I was a community organizer, and I was what was known as a bomb thrower by the mayor of the city of Rochester, the city council, because I was a paid community organizer. And I did some national organizing, is that every good grassroots organization has people involved that can provide free housing. And I can't tell you what a difference that makes. So, Jeff, that was phenomenal. First time I went to Jeff's house, he showed me all the toys he had bought with some of his compensation money. And the electric drapes. I felt I was Jeffrey mentioned that he didn't participate, and then he organized it.
Well, I'm gonna try to finish up quickly, and hopefully this time I won't break out in hives.
Don't worry, we didn't notice.
Yes, you did. Anyways, I want to thank you, Bill and Jeff. 3 years ago, we began to live a nightmare. And I remember the first time that Alexis and Heidi and I got in the car and we said, we just have to meet Bill and Jeff. We have to do something because we need that power that you're talking about behind us, because we were really alone. We have loved ones and friends here, closely supporting Dylan, but we needed that power and alignment of groups behind us. So we went out to Montclair University, and that was the first time that we had the pleasure of meeting both Bill and Jeffrey. And I remember specifically your articulation that evening, Jeffrey, and how clear you were about your mission, and I could see that we could align with your goals and your cause, and going to Albany and getting involved in the commission bill. And since that point, we've really come a long way. It started with just 3 women, and now we are 3 women, a wonderful supportive group. We have a name, Voices for the Falsely Accused. We have Jeff and we have Bill, and we stand behind you. And we are, just a few thoughts I want to put out there without being too long. I just want to give a brief update on how Dylan is doing. Obviously, most of you have been in there. In fact, all of you have been in there to see Dylan. And it's getting a bit tougher as he's approaching the halfway mark. He is ripped and torn between whether to, first of all, we all know why he took the plea bargain. He was under a severe amount of pressure. He was in a situation where he was looking at a possible 25 years to life, so he did what he had to do at that point. He's having difficulty with living with himself and what he said that he didn't do. So we're at a turning point now, I believe, where he's feeling he should appeal. We have 2 attorneys. I'm not, are you taping me now?
Yeah,
Is it okay if we turn that off?
definitely.